By converting a case, you essentially take the control of the property away from the debtor and you give it to this third-party trustee.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Today I'm joined by one of the best bankruptcy litigation attorneys in the state of New York, Michael Rozea. We're going to be diving into a nuanced area of bankruptcy law, the process of converting Chapter 11 cases to Chapter 7 cases, allowing trustees to sell properties free and clear of liens even if the debtor objects. We're going to break down the legal framework, recent case developments, and the practical implications creditors need to know when contemplating this type of action. Before we jump all the way in, let's first talk about a really simple aspect of our conversation. What is the difference between a Chapter 11 and a Chapter 7?
Very easy. A Chapter 11 is a reorganization process for the debtor where the debtor is going to deal with all of their debts within the context of that bankruptcy case and then file a plan to address it. In a Chapter 7, it's just a straight liquidation. Debtor is filing, presumably gets a discharge, and that is the end of a case.
At what point in time is someone saying, I really want to convert this from an 11 to a 7 to get the property sold?
Right. I think that's a great question. It's not going to be a motion that you file right in the beginning of a bankruptcy case. A bankruptcy court's going to give a debtor time to formulate a plan and address it. It's more when there's been no action by the debtor or actions that adversely affect the secured creditor's rights with respect to the property. A lot of times, this sort of motion will be considered after about 6 to 12 months within a Chapter 11 case. And then after that, then it's ultimately left to the discretion of the bankruptcy court in whether to grant it or not.
So let's say I'm a really aggressive mortgage holder, right? And I really want to do this. I listen to this Weekly Friedman and I say, man, I would really, really like to convert my Chapter 11 to a 7. Are we really saying like 6 months is like the minimum? Are there ever times, are there ever circumstances where we can say after 3 months we can try and do this process? Or are we really always saying it's got to be 6 months?
I think you need to look at it from a jurisdiction perspective. And here in New York, bankruptcy courts are generally pretty debtor friendly and they're going to permit a debtor some time to formulate a plan. If that's 3 months, if that's 6 months, it's really fact dependent, but they are ultimately going to give a Chapter 11 debtor time to formulate a plan.
I want to focus in on what you just said there, where you said the time frame is really related to whether or not the bankruptcy debtor has formulated a plan by the 6 month time period, right? When you say that, can they just propose a plan that makes no sense? Can it just be like a sham plan and then they've satisfied it? Or is it like they have to propose a plan that's reasonable?
I think that initially it's really just proposing the plan. That's going to buy a debtor some time for the court to consider and analyze the prospects of the plan. It then takes a active secured creditor or any sort of creditor to voice its objection to the plan and the issues with it. Hey, you're not paying us in full. You're not paying us the correct interest rate. Hey, this just is not feasible. There's no way you're going to be able to sell those property. And those are all active things the creditors' counsel has to take in a bankruptcy case.
Obviously, the benefit of undergoing this process, converting from an 11 to a 7 and selling the property, is really that the creditor gets a resolution. Is there no way to sell the property within the 11 and get the same type of a resolution?
Well, there certainly is an element, but when the case is in the 11, the property is in the control of the debtor. So we're subject to whatever the debtor's principals want to do with the property. By converting a case, you essentially take the control of the property away from the debtor and you give it to this third-party trustee who then is going to analyze the situation and then decide if it makes sense to sell the property.
Let's say the debtor does not submit any plan, right? But there are lots of other assets. There's millions of properties, or there's other types of, there's businesses, there's a lot of different things that are in there. Is it feasible to do this, or it really needs to be like a single asset company that filed the 11 where this is a feasible process?
In the asset heavy cases, you're going to have more of a push for a conversion because there are those assets to presumably distribute to the creditor base. In a single asset case, it's kind of more difficult to convert a case because it's just that one asset. It's a two-party dispute. What really is the point to a Chapter 7 trustee selling the property? Because there's not going to be any distribution to any other creditors. It's just that one creditor here.
Wait, so this is interesting. So you're saying if there was only one asset, it's easier to just do it in the 11?
It would be, yes, because you have that one asset to administer here. The only time where conversion would make sense is in a situation where, hey, the property is dangerous, the debtor's not doing anything, we need to get this property out of debtor control. or if there's equity in the property and the debtor's sitting on it and just trying to delay the game. If that's the case and you make a sufficient showing to the court under 1112B that it's in the best interest of the court, best interest of the creditors to convert the case, then you have a shot at conversion here, and the trustee then can take control as an independent party.
When we're saying we're converting the case, is the 11 still going to exist?
No, the 11 estate converts to a Chapter 7 estate.
So the reason why I'm asking is, let's say there are numerous assets, right? And we're saying we're going to convert to a 7. All those assets are converting to a 7 and being sold?
That is correct. Always.
Okay. Let's make this more real. Like, do we have a situation that we've experienced where you've gone through this process, like recently?
We're currently involved in one, yes.
Okay. And so what's happened so far and what will happen in the future?
Sure. Debtor filed a single asset real estate case in June 2023. They had a property in Brooklyn. Debtor sat on this case, and during this time, squatters entered the building. They kept representing they couldn't remove the squatters. They obtained an order from the bankruptcy court to evict them with the assistance of the marshals. And ultimately, when the court said, hey, when are you going to evict these people? They said, we don't have a deal with the secured creditor. We just want to dismiss out of this case. We then pushed, after consulting with the client, for conversion so that we could take this property out of control of the debtor, move it to a Chapter 7 trustee who can evict those squatters, which is now done, and then proceed then to market the property and then to sell the property the highest and best offer.
If I'm a creditor, I'm a mortgage holder, and I'm hearing this video and I'm saying, I wish I could do this in my cases or something like that. Is there any other relevant case law or decisions that come into the evaluation that they should be aware of?
Absolutely. It's statutory. It's 1112B of the Bankruptcy Code, and that's the best interest of the creditors is what the court is to determine. In our case, the debtor wasn't doing anything. The property was just letting it get into a state of disrepair. And in light of that, it was ultimately a very difficult decision to get the court to sway with us, even with this fact pattern. But ultimately they did, and she converted the case as a result.
So I think this is an interesting topic because 11s occur frequently within the default world, but they're not that frequent, right? You're normally seeing 7s and 13s. And I also think this idea of converting an 11 to a 7 is something that I could already see every investor we work with, as soon as they see an 11, say, I saw that video, let's convert to a 7 right now, right? So it's interesting to hear the process of how this works through, right? There's a period of time. We're giving them a period of time to submit their plan, see if it's reasonable. And we're also looking to see this almost, I forget what the word you use, but almost like an unfairness going on or something.
Best interest of the
best
creditors.
Interest. And I think that's a good evaluation.
One thing I'll just add, and the reason why you should really consult with counsel before electing to proceed with this is because while the property is going to transfer to a Chapter 7 trustee, there then are costs that's affiliated with it. There's the cost for the broker, there's a trustee commissions, and then there's trustees counsel. So you have this additional layer of administrative expenses that are going to come up that you're going to have to pay, but you're short-circuiting the whole foreclosure process then. You're selling the property free and clean of all liens, and you're done with it at that point. Whereas in the case that we had here, you're going to have to deal with all these evictions of all these squatters otherwise too. So you have those costs on the front end, but then you also eliminate the costs on the back end.
Not to put you on the spot, is there a range of what those costs are?
Oh, yeah. I mean, so it's trustee commissions. It's just based upon how much is distributed here. The higher up, the
higher it goes.
Yeah, the higher it goes, essentially. And trustees' legal fees are the trustees' legal fees. Right. And then you have an auctioneer, too. In a lot of cases, they have a broker's commission that'll just come on the back end. So it's not necessarily coming out of the pot of money that comes in, but it is an expense then that wouldn't go into the ultimate sale price.
Yeah, I think it's probably something you have to factor in when you're evaluating the case. Look at the property, what's it worth, what's the equity spread. Obviously, if there's a ton of equity, you would look at it differently. I gather there's not normally probably a ton of equity.
It would. I don't think the property would be in bankruptcy if there was equity. But if you have situations that you were talking about where you have also other assets that maybe cross-collateralized, this situation may come up.
Look, I really appreciate it. Very interesting. I hope you enjoyed your first time on the Weekly Friedman. I hope we get you back on here soon.
Great. Thank you for having me. It was really a lot of fun.
Thanks a lot. Thanks for joining Mike, Rozea, and I on the Weekly Friedman, your source for the most essential information in the default industry.